Thank you for asking me to be here today. I was asked to talk about the work that I'm doing in terms of my PhD. I'm currently at the thesis stage, and I've done a fair bit of research, empirical research, in terms of talking to lawyers and judges in Alberta that I'll talk to you a little bit more about this particular issue. As you know, because you live in one of the provinces that includes unmarried cohabitants, it's really a non-issue here in British Columbia. As of March of 2013, your new Family Law Act allows for persons who have been in relationships for more than 2 years, marriage-like relationships, to apply for a division of property. So in British Columbia, it has become much more of a non-issue. One of the issues in BC that seems to be hitting the courts is what is a marriage-like relationship, and whether there's going to be issues in terms of how long somebody's lived together and that sort of thing. But in terms of the concept of including both folks who are married and folks who are not married into a matrimonial property regime, you've accepted that here. And that's great. There are other provinces as well in the country that have also done that, and starting with Saskatchewan in 2001, Manitoba in 2004, the Northwest Territories actually were the first in the late 90s, and Nunavut. Those provinces all see this as a non-issue, because in all of those provinces and territories we have a system which includes common law folks in the marital property regime. So provided that you meet certain criteria, for instance 2 years here that you've lived together, you can apply if you've been living together, and you can apply for a fair division, an equitable division of property. And so for a lot of people, they don't really think about it. For me, I lived in a province of Alberta, and in Alberta, they're not moving at all towards this particular. They're not making any changes or movement. And the Institute of Law Research and Reform out of Alberta has really taken a non-position, and they haven't wanted to look at this. The big provinces of Ontario and Quebec, which I'll talk about later, are also not taking a stand on this particular issue. So I came to this topic, and I'll give you some background, because I graduated at the University of Alberta Law School in 1978. And I was sort of that first wave of big classes of women. I think we were at like 35%. And I was admitted to the bar in 1979, and I was very fortunate to have articled with at that time, one of the leading family law lawyers. So because of my interest in family law, which developed while I was in law school, because again, I was fortunate to have a great professor, and then I was really lucky to be able to article with Max Smith, who later became a justice of the Court of Queen's Bench. I ended up doing family law, and since June of 1979, I practice exclusively in the area of family law. And I have, when I studied family law, and when I started studying family law in my second year was 1976. During that period of time, we didn't have matrimonial property legislation, so that married folks did not have any sort of legal protection once there was a dissolution of the marriage with regard to property. So married women, particularly, and those are the ones I was mostly concerned about, were not entitled to a share of property acquired. Sorry.
Your microphone's just sort of tucked under your jacket, so we're not hearing you. Oh. Sorry, it was open for. Okay, thanks.
Which is the most important.
So it's okay. So married women were not entitled to a share of property acquired during the marriage unless their name was on title. And for the majority, and remember, Alberta even back then was very much of a farm province, a rural province. So the majority of farm women in particular, this had a major effect, because these women usually lived on farms with their husbands, worked hard on farms with their husbands as equal partners, but the property was generally in the name of the man. And when they split up, if they chose to leave a difficult relationship, they received nothing. They might have been entitled to some spousal support, although even that was very minimal. So this is what I was working with when I was in law school. And when I was being taught by my family law teacher, we were taught the case law related to trust actions. And the courts at that time, both in Canada and Britain, were struggling to find ways of coming up with how are we going to give women some share of property when the marriage dissolves. And because there was no legislation, what did they do? They relied on trust. And there were a whole series of cases, specifically on what we would refer to as resulting trusts. And these cases required women to come in to show that they've made a financial contribution to the acquisition of property, which was difficult. Because not only did they have to show working on the farm wasn't good enough in those initial sort of years. So I grew up in terms of the world where there was a real limitation on women's ability to obtain a fair share of property that was acquired. Contribution, both financial or later non-financial, was considered, but it was considered in a very limited fashion. So that's the 70s. And it wasn't really until the mid-70s as well that we had a decision that really came out of the Supreme Court of Canada, Murdoch, which some of you who are older will know about, which brought the injustice of this, of trust and the injustice of women's inability to access property, entitlement, to a forefront. And Murdoch was a situation, came out of Alberta. Most of the strong trust cases have actually come out of Alberta, where a woman who, after 43 years of marriage, married to a very abusive male, separates from her husband to receive nothing except for some spousal support. But it was that decision which had a very strong dissent by Justice Laskin of the Supremes, and he wrote a decision which brought in the concept of constructive trust from the United States. And that decision, the dissent, became part of our law over a series of further decisions made by the Supreme Court of Canada after Murdoch. So what Murdoch did is it galvanized people in many respects. I mean, people were already galvanized, but it made it even more so. So when that came out, pretty well the Institutes of Law Research and Reform across Canada began doing research and preparing reports. And in Alberta, the Institute of Law Research and Reform came out with their report in 1975. So you had governments across the country looking for an answer. Remember, at the same time that this was all going on, in 1968, Trudeau had liberalized divorce law, which allowed people to get out of bad marriages much easier than they had before. So we had the liberalization of divorce law, and the new Divorce Act, the 68 Act, allowed for spousal and child support. But we didn't have any property division at that point. We had Murdoch, which then brings out the injustice of a long-term relationship where somebody walks out of a relationship with nothing. We have the Royal Commission on the Status of Women, which issued their report in 1970, which recommended that the provinces and territories look at legislation to equalize property that's acquired during the course of the marriage. In other words, give women a share of the marriage upon dissolution. And we had government and institutes of law, research, and reform across the country looking at that. And when I was in my second year of law school, the Institute of Law in Alberta had prepared a report with two recommendations. One looking at what we ended up with, deferred sharing, saying, okay, if there is a separation, or if there is a separation at that time, there will be a presumption of sharing of assets that were acquired during the course of the marriage. The minority report wanted to go to a system which Britain had taken on in 1965, which is called, which is basically a discretionary approach, which allows the judges to determine whether or not there should be equality. And for many years in Britain, until a decision called White came out in the late 90s, early 2000s, there was no presumption of equal sharing. So there was an issue as to whether or not we would go deferred, which was, I think, a fair approach, or whether we would go the discretionary. And that was an issue that was being dealt with across the country. So my first summer job was visit Alberta. I got to go with a traveling puppet show with that, which went around talking about law stuff. And I got to go travel around, sleep in trailers. I've never wanted to sleep in trailers after that. And I spent my summer talking to women's groups. I was so fortunate. And I went to every small town in Alberta, and I was given the opportunity to meet women from across, particularly women who had worked in the area of farm wives, you know, the UFA, all these farm women's organizations. And I got to talk to them about the new report and what the Institute was suggesting. And it really opened my eyes in terms of what there was out there. Because when you live in the city, you know, my family, the properties were, I never really thought about this, but I mean, my parents always had a jointly owned home. Didn't really think about that. But it was in the farm areas that we saw the difficulties. So the act was passed in 1978. At that time, the Conservatives were they were progressive in some respects, and they passed this legislation in 78. And when I started articling in 79, this was my world. And so my world, from the beginning of my articles, was the concept of sharing of assets acquired during the course of the marriage, subject to certain exemptions, the things you had before the marriage and that sort of thing. And I did all of my case law, and in terms of my litigation experience, related to that. But when the Matrimonial Property Act came out in Alberta and the rest of the country, there were discussions as to whether or not we would include common law folks. And that was discussed in every single province. But at the time, in the late 70s, early 80s, it wasn't until 81 actually that they started recording how many people live in common law relationships. But the very first census which actually recorded that was in 81, and they showed only 4% of the people. So when this was being approached by the various legislatures, this issue as to do we include common law relationships, common law relationships were small in number, and they tended to be alternative lifestyles. You know, people in the 70. I can't remember anymore when I was doing what I was doing. In 75, I lived common law with a fellow for a year. I mean, it was sort of the hippie sort of stage. It was those of us, you know, you wanted to try it out. But it wasn't, you didn't see these sort of longer term sort of relationships on the whole. So people weren't thinking about that at all back in those days. We weren't thinking in terms of this. As feminists, we were worried about one thing, and that was trying to get a fair shake in terms of property division for married folks, because that's who the majority was. And then, while I was started to practice, and we started thinking about what will happen in terms of common law relationships, because then cases started to come to the forefront. And in the late 70s, early 80s, we saw a number of cases of constructive trust where people were coming to court saying, well, you know, I wasn't married, but I think I'm still entitled to a share of property. And there was a series of 3 cases which developed what we refer to now as constructive trust. And those 3 cases were Rathwell versus Rathwell, which actually involved the married folk, Pectus versus Becker, and Peter versus Beblow, all written by, as Leroux Dubé calls him, the first feminist on the Supreme Court of Canada, Justice Brian Dixon. And he wrote these, and his second, and sorry, I forgot Sorokin. 2 of the decisions, Pectus versus Becker was the very first one that dealt with the common law relationships. And the husband in that case argued that Ms. Becker should not receive anything, and the reason she shouldn't receive anything is because they weren't married. And the trial judge, this was an Ontario case, agreed. It went to the Court of Appeal, and Madam Justice Wilson, who then went on to the Supreme Court of Canada, wrote an incredible decision, which was later accepted by Justice Dixon, wrote the decision saying it doesn't matter whether they're married or not. They've got the same issues. This was a long-term relationship, Pectus versus Becker, 40-odd years as well. She should be entitled to a share of the property. And that was the beginning of property rights for common law relationships. We had Pectus versus Becker in about 1980. After that, there was a case of a Sorokin versus Sorokin, which was another Alberta farm case where a couple lives together for 43 years. They have 6 children. But when they got started, he already owned the property. And he was saying, hey, financial contribution means you got to contribute at the beginning of the relationship, not during the course of the relationship. Supreme Court of Canada says, no. We're going to expand this concept of constructive trust. And Canada has been the place where constructive trust in the family law area has really developed. And over the years, the concept of constructive trust, which basically is this, is saying you, I'll use the male, man, Mr. Pectus in this case, were unjustly enriched by the work that was done by Ms. Becker. And therefore, Ms. Becker is entitled to a share of the fruits of your labor. And that's, it's obviously more complicated than that. But constructive trust developed as a need, to fill a need, because there was a legislative gap which prevented persons in common law relationships to access the issue of, or to access marital property regimes. And over time, since then, what we've seen is a societal shift in terms of common law relationships. People live together a lot more. In the most recent census, we have, the numbers are about 14 to 18% across the country. In Alberta, it's 18%, and part of that is because we have a fairly young population in Alberta. Ontario seems to be lower at 11%, and in Quebec, it has the highest. And Quebec has 38% of folks who are living in common law relationship, who have made either a choice or cannot marry, and they live in outside of the marital status. So more people over the years that I've been in practice were rejecting marriage, and they were living in common law relationships. Now, what did the world do, or how did that change things? Well, over the years, what we've seen is some real shifts in terms of thinking. So that most people today, if you ask them, well, do common law folks get a share of the property at the time? Are they entitled to half the property? They'll say yes. That is, and we've got research to show that. Do most folks think that relationships that are unmarried relationships are treated the same way in law as a marriage? Yes. Most people think that today. Why is it that we have that thinking? Well, we have that thinking because as time has gone on, and there have been several cases that have gone to the Supreme Court of Canada, governments have changed their regulations and included non-married folks within certain parts of law. For instance, in every province in this country, save for Quebec, and I don't really want to spend my time today talking about Quebec because that would take a whole lecture, but save for Quebec, a woman who lives with a man for either more than 2 or 3 years, and there's provisions in terms of time, can apply for spousal support. And the rules of spousal support are essentially the same as if they were married. There's some variations in Alberta particularly, but they're essentially the same. If you live together and you have children and you're not married, you will get child support just like an individual who is living in a marriage relationship. In fact, the child support guidelines, the federal child support guidelines are accepted under the Divorce Act, are accepted in all provinces save Quebec. Now, unfortunately, in Quebec, not only do you not get spousal support or a right to divide up property, but your child support is substantially lower as well. So it's just like there's a lot of work that needs to be done there. But in the rest of the country, you ask for child support, you're not married, you will get child support. Property or pension, CPP, you will receive. All of these things, benefits, if you're living in a common law relationship and your spouse has benefits, you will receive. Life insurance benefits, you will receive. Estate benefits, you can receive depending on the circumstances. But so we have this massive legislation and law that has developed both in case law at the Supreme Court of Canada level and at the provincial levels, and in legislation which treats married folks the same as unmarried, save and except for one thing, and that is the property. And that continues to be the last bastion at this point in terms of trying to move things ahead. So you think, and so some of you may think, well, why is it important? What difference does it make? People choose to marry. They choose to accept the obligations with regard to marriage. So really, what difference does it make when it comes to property? And where I came from is I did, in my practice and still do, I've done a number of decisions or worked on a number of cases involving common law relationships. And I've had to deal with proving trusts. And one of the things that I've found in terms of the issue of gender is that primarily it's the woman, and in all of my doctrinal research, about 75 to 80% of the people who apply for a division of property when they're unmarried under constructive trust rules are women. It affects women more. Why is that? Is because if they're living in a common law relationship, property tends to be in the man's name because he has more of the financial wherewithal for many reasons. So the cases that I've done, and I've done cases on both sides of the equation. And, I'm a litigator, so I've acted for men in these cases, and I've acted for women in these cases. And when I came to decide to do a PhD, this is the area that I wanted to do because I wanted to really take a look to be able to convince the Alberta government and some of the other governments, if I could, to change their way of thinking. Because as a lawyer and person who has been very intimately involved with the constructive cases, trust cases, I have found that they are lacking. I have found that they are very difficult to do. I have found that they are humiliating. I have found that they are denigrating, particularly to women. I've had women on the stand in constructive trust because in constructive trust, in order to be successful, you need to prove contribution. You need to be able to show that I have contributed to this relationship, whether it's financial or whether it's non-financial, doing domestic work, having kids, looking after the house, maybe taking phone calls for the business, etc. That's what you have to prove. And in order to, unlike matrimonial property legislation where contribution is presumed, you walk into a divorce. If you've been married and you walk into a divorce action, no one asks you whether or not you've ever been to the business or whether you've made any contribution to the business in Alberta because it's an equal split. No one asks you that. Your contribution, be it in working outside the home, be it as having children, be it as working inside the home, is presumed. But in constructive trust, you must prove it. The onus is on the individual who comes into this courtroom and says, I want a share of this property that was acquired during the course of the relationship. And unlike marital property, which presumes equal sharing and says property should be divided equally, there's no presumption of equality. So there's no presumption of contributions. In other words, it doesn't matter who did what. There's no presumption of that. There's no presumption of equality. So even if you can prove that you, as an individual, have contributed, that you've worked on the farm, that you've worked in the business, or whatever, that you've had kids, that doesn't give you a 50% share. Because at that point, the court then has to look at the next issue. And the next issue is, well, what benefits, dear, did you receive? What benefits did you get? Did you get free rent? Did you get nice trips? Did you get nice clothes? And then the court can start offsetting those benefits as opposed to the contributions. So these cases are fraught with difficulty. They are long, they are tedious, they are, and as I've said, I think they're humiliating to individuals because you have to basically come in and you're almost like you know, I've seen women get up on the stand and have to say, well, I spent 4 hours a day doing housework, and these are all the things I did. And I spent, you know, I provided companionship. I provided, I went out for the business, I went out and picked up the parts, or whatever. They have to itemize this, and what that means is that it takes a long time. These cases are very, very long, usually. It also means that people are afraid to litigate these cases, because where you don't have rules, and we know this, if you don't have rules set out, it's difficult to get to say to a client, I think you've got a great case. I think you've got a great case, so let's litigate it. And what's happened to this point is because of the way the constructive trust cases have come about, and the most recent one was out of the Supreme Court of Canada, Kerr versus Barno, who everybody said, oh, isn't this lovely? We now have a roadmap, which we do. I think the last case has made these constructive trust cases even more difficult. But so even though we have a developed body of law, and I've read a lot of them, what I'm seeing, despite this developed body of law, is I'm seeing in my research, in my doctrinal research, that if you have fully contributed to a relationship and you have done all the things you could possibly do, there's no more that you could, you're going to get between 25 and 35%. And that's what common law spouses generally, almost all of them, is 25 to 35. And the two cases that came out of the Supreme Court of Canada, Kerr versus Barno and Vaness versus Seguin, are prime examples of the inequities. And what was disturbing about the Supreme Court of Canada decision, which came out in 2011, was the fact that not one of the justices at the Supreme Court of Canada decision at that level came and said, you know, this is really unfair. This just doesn't sound right. And Kerr is, I'll just give you a brief facts about Kerr, 26-year relationship. They were sort of older when they got together. During the course of the relationship, they acquired a house. They built a house on property that he owned before. He acquired a bunch of investments. She acquired some investments. But because women tend to make less than men, for many reasons, her investments were not as big as his investments. She walked out of the relationship after having suffered a stroke. She walks out of a relationship with, at the trial level, a third of the assets of the house. There was no sharing of the pension and those contributions. He was left with his, I think, $900,000 in investments, and she was left with her $200,000 and some in investments. No sharing in investments, but she gets a third. But Kerr is a really good example of the difficulties that come up with these cases. Because Ms. Kerr, in that situation, she was able to show massive contributions, maybe not so much financial, but she was able to show a lot of contributions. They both worked during the relationship, so financial as well, and also to the household. And had they been married, it would have been an automatic 50-50 split. But she walks out, but there, not only was he happy about the fact that he only had to pay her a third of the house, which was, I think, $300,000 and some, big deal, out of a $940,000 house, because he's left with the property, and this is Vancouver. And so I'm sure it's doubled now. He wasn't happy. So he goes to the BC Court of Appeal. And he's not happy about that. And he ends up at the Supreme Court of Canada level. And what does the Supreme Court of Canada say? Well, the BC Court of Appeal was wrong because they denied her claim ultimately. The BC Court of Appeal is wrong. The Supreme said it has to go back to trial. So Ms. Kerr, who's in a nursing home, has gone through the first trial, Court of Appeal, Supreme Court of Canada, and then she goes back to trial, 6 days in a courtroom, and the judge finds that she's contributed. But he offsets, or she, I can't remember who it was, offsets the contributions that were made by him in terms of the, that she was living in his house and that sort of thing. And she ended up getting 25%. So instead of 33, she ends up getting, and that was after a 6-day trial. So that case is a really good example of what's wrong with the exclusion of folks from matrimonial property regimes, those people who are not married. It's a great example. The other case is Vaness, and they also dealt with this, and that's an Ontario case. And they start out, this young couple, start out with nothing. They have 2 kids. She's working for a while at CISA. Then she takes time off, which is fairly typical. He starts an IT business, and luck has it, he sells it for $11 million. And then they split up. And when it goes to the Ontario court, the court looks at this, and they divide the relationship up. And they say, well, during the first part of the relationship, she's not really entitled. During the second part of the relationship, there's an entitlement. She'll get 50% of the increase during that time. And the third part of the relationship, because they moved back to Ontario from Nova Scotia where they'd been living because she wanted to live there, and he was a helpful dad. He wasn't working anymore. She's not entitled there. So she walks out of this relationship in Venice with a little over $1 million in the total, and he walks out with $7.4 million. Again, lengthy trial. Now, when it went to the Supreme Court of Canada, the Supreme Court of Canada left or reinstated the trial judge's decision, and so she ended up with her a little over $1 million. But you can see there is a relationship where they get married, they have very little, they work together in a business. She works, she contributes, she has babies, and she comes out with 17% in numbers. 17%, and he comes out with the rest. So these cases, those two cases, and the most recent ones that have come out of Alberta, there are two major cases out of Alberta. Same thing. In both those cases, they were both farm cases. And again, in both of those cases, long-term relationships, they walk out with about 30 to 35% of the assets. So those cases and all of the cases that I've looked at illustrate to me, and the ones I've done personally, illustrate to me that excluding folks from common law relationships is just not fair. And it isn't fair, and it's particularly not fair for women. It's women who are usually the ones that are economically less able to proceed with these type of cases. It's women who generally do not have the property in their name, and particularly in Alberta. Alberta is really a good example of what can really go wrong in these cases. And the reason is Alberta, as you probably know, is all fueled by oil money. And there is so much money in Alberta, but mostly in the hands of men who have started little oil field companies that are worth millions of dollars. And I see them every single day of my practice. Millions. And they're always in his name. Always. Pretty well. I mean, sometimes you'll see them joined. But primarily they're in his name. So in Alberta, women make about 55% of what a man makes. Now, and the reason for that is because the males tend to be working in the oil field. And the oil field skews a lot of things, and it certainly skews incomes. So that you have a situation where in Alberta, you've got women who are living in common law relationships generally making a whole lot less than men. So as a result, it is very difficult for them to prove the financial contribution to the relationship. That becomes very difficult, and you need to prove contribution in a relationship. Now, Peter versus Beblo out of the Supreme Court of Canada in the 90s, which I see as a high point, said that domestic work is treated in the same, it should be treated in the same way as financial work, going out and having a job. But as I've seen the cases that have gone since then, and as my research has shown, or has shown me particularly, is that it is still the case that domestic contributions, staying at home with kids, is still not viewed as valid as going out and making the money. I just see that time and time again. And that's one of the reasons why we're seeing the cases coming out with 35% in constructive trust cases. So at this point, we are in most of the country, and I haven't talked to you, I don't think I have much time here, I haven't talked to you about Eric and Lola. The Supreme Court of Canada has had two opportunities to strike down the exclusion of common law folks in marital property regimes. One in 2001, where 8 judges out of 9 said that it was not discriminatory on the basis that people choose to get married. And only one judge, Justice Leroux-Dubé, who said, yes, it is discriminatory because you don't need to look at, it's not a question of choice in many respects. People don't get married because they know they're going to have the Matrimonial Property Act apply. Sometimes they can't marry for whatever reason. but she was in dissent. And that was one opportunity. So that in 2001, when that case came out, and I remember it well because I was in the middle of a trial involving common law relationships where I was acting for the guy, and all of a sudden the rules changed because we had this case, and my guy was quite successful in the end result. And then they had the opportunity, nothing sort of happened until the Quebec case that came out in 2013, in January of 2013, called Eric and Lola. And that was where Lola was making a claim to, saying that the lack of her ability to access property rights and spousal support in that case, because she was an unmarried person, was discriminatory under Section 15. The Supreme Court of Canada, 5 judges found that yes, it was discriminatory, whereas in Walsh they said no, 8 judges said that it wasn't. But unfortunately, one of the judges found that it was saved under Section 1. It was a reasonable, it was saved under Section 1, which means that we now have a situation where we have the Supreme Court of Canada, the majority of the Supreme Court of Canada saying to lawyers, I guess, that yes, it is under Section 15 to exclude, but because of the Constitution, Section 1, we've saved it. And so, and we want the governments of the various provinces, in particular Quebec, to take a look at this issue and to make the changes themselves. We're going to defer to the legislature. And so we are now in a position where we know it's discriminatory, and I'm hoping that somebody takes it again. I think that in another province we might be successful of overturning Walsh, but we are now in a position where we know it's discriminatory to exclude. So the question now becomes, it's up to the governments. And it's up to the governments of Alberta, of Quebec, Ontario, and the Maritimes to take a look at it. The only province that's actually taking a look at it now is Nova Scotia. Their institute is preparing a report as we speak, because in Nova Scotia, after Walsh came out, which was out of their jurisdiction, they came out with what we call a domestic partnership. And that's a big issue in these situations, as to whether we go with just straight inclusion. We just say people can opt or can get in, or whether they have to opt in by way of signing a contract. And what they found in Nova Scotia is people tended not to go to the registry office and sign up for a domestic partnership. So it doesn't work, and we know that it doesn't work well in the rest of in other countries as well, particularly France. So the governments Nova Scotia is looking to change to a similar process that you have here in BC. The Conseil des Femmes in Quebec is also looking at it, but there's a lot of pushback from some of the older feminists who really want autonomy to be #1 priority for women. They don't want women to have to be dependent on trying to get property from their spouse. They want them to be, and unfortunately, as laudable as that is, it doesn't always work, and it hasn't worked in Quebec. So we're now in a position where we're waiting for the governments to do something. I think that Quebec is going to be a long time coming, particularly if the current government is re-elected. I think that Alberta is not anywhere near it, near coming to this conclusion. Ontario, I don't know really what's happening in Ontario. They don't seem to be touching it with their law commission is not touching it. So I'm not sure where they're coming from. And then I think in Ontario they feel that there's less urgency. But I think that the opportunity to push government to change this and to get people thinking about it is is the Supreme Court of Canada has also come out with a report called Access to Justice. And they're talking about, and one of their family law report was meaningful change for family justice beyond wise words. And one of the things, and this was written by Justice Cromwell and a number of people, including one senior person here at UVic. But this report was talking about this, the idea of being able, for people to be able to access justice in family law. And they looked at a number of things. I mean, they obviously looked at legal aid, because there's been cutbacks across the country. But one of the things that Justice Cromwell and the people who wrote this said is that the more regulation, the more rules, if you will, you have, the easier it is for people to access justice, right? So you have matrimonial property legislation, which provides for a sharing of property. That's good. You have rules. You have child support guidelines. That's made child support litigation a lot less. I mean, people still argue over these things, over child support, but there's a whole lot less of it. Spousal support guidelines. Yes, they're advisory, but hey, they're there. And we can, as lawyers, we can rely on it. So, in a lot, Cromwell in his report is saying rules and regs are good. Now, people, there are a lot of leaders, particularly in Alberta, they don't like that, but they work. Our life since the child support guidelines have come in has made child support really a lot easier. When I first started practicing law, it was $100 a month was, oh, gee, you're getting $100. You were beholding if you were a woman asking for support. You had to prove again that you should receive child support. It wasn't until a number of females were appointed to the bench that people started talking about child support. We had a judge in Edmonton who used to come in with a bag of groceries. Say, do you know how much this cost? They used to discuss how much it costs at the beginning of school year for the runners. So that started judges thinking, and then of course that led to changes in legislation, the child support guidelines. But it's that need, I think, for rules and some that people we should be working towards. And I think as feminists, because of the lack of legal aid is another example. It's being cut across the country. Legal aid in this province is probably non-existent. Because constructive trust is difficult, because it is an expensive process, people who are out there that are probably entitled to share in property are not, because they're being discouraged by lawyers like me. People come in to me and they're talking common law relationships, and I say, well, it's in Alberta there's no presumption of equality. It's going to be very difficult. I might be able to get you 30%, but it's going to cost you X amount of dollars to get there. And I can't guarantee it. So you have the ability to, there are this, in my view, and I don't have any proof of this, but except anecdotal. There are this whole group of people who are maybe have lived together for 7, 10 years, who are going to lawyers who are saying, I just don't think you're going to be successful, or it's going to cost X amount of dollars to get what should be rightfully yours. So these are, with legal aid, you can't get a legal aid lawyer, so you can't access justice. So the cost you can't access, and it's going to be women, because they're not the ones running the little oil field companies and who have a lot of money to spend on people like myself to fight these cases. And as feminists, we spent a lot of time working on bringing in same-sex couples into marriage. And when we did that, as good as that goal was, and it was good, what we did is we forgot this other 18%. And in Quebec, 38%. And I think we now need to look at that issue and say, okay, this is a feminist issue. This does affect women more so than men. And even if men get gets a share of property after they've lived in a relationship for many years and all the properties, and that's a good thing because that's fair. That is justice, and that's the way we should be living. And to exclude people from regimes, fairness regimes, just on the basis that they went out and they got a marriage certificate, I think is wrong. And I think it's even more so now. It really bothers me, and I can't explain to you how much it bothers me, but whenever I read these cases, and I read a lot of them, it just makes me so angry about, and I know that for a lot of people, a lot of people are going to come to me, they say to me, and even my own girlfriends, well, why should we impose this on people living common law? They said the same thing to me in 1975 when I was walking around the countryside in Alberta as to why should we impose matrimonial property regime on people now? Because, of course, the regime was retroactive. Why should we impose this? When people got married in the 50s, they knew they weren't going to share. Why should we be doing it now? Because it was fair. And now, for common law folks, for those 18% of folks that are living outside of a marital regime for whatever reason, and it doesn't matter, we shouldn't judge people, it's fair. And the time is now to do it, like BC did it. And if I could just convince Alberta, hey, or Ontario, and particularly Quebec. Anyway, those are all my comments.
We do have the room for a little bit longer, so if there are questions from people who would like to question or challenge you or disagree or agree. Doug has a question.
Thank you very much. That was really interesting. My question is whether your review of the case law is revealing why constructive trust isn't working. There's nothing inherent in the doctrine of constructive trust as a remedy for unjust enrichment that would peg the returns at 30 to 35%. It could as easily be 50% or 60% for the non-property spouse. So I'm wondering why you think constructive trust hasn't been working. I would guess that one answer might be that the people here in these cases are men, or at least disproportionately men, although if Peter and Bevel is a high water mark, I suspect the ratio of women on the bench has improved since then, and so you would expect. So why isn't constructive trust working?
Because what I've seen over from Peter versus Bevel, if you were Peter versus Bevel today, if that case was being heard today, she would not have received what she did. Because the concept of benefits received, sort of cutting away at what a person's entitlement, wasn't fully developed in Peters versus Bevel. Not at all. It has been much more so developed, so that people are coming back now. The other side, men are coming back and say, "Well, yeah, but look at what she's received, what she's benefited from that." And the other problem with constructive trust is that judges are starting out with the zero mark, right? When you're in a matrimonial property, you start with 50-50. The judges that I've interviewed all say to me, pretty well all say to me the same thing, is that they start with zero and they're working up. Conceptually, that's a very big thing. But I don't know if I could say that there's a difference in terms of the way men view women's work or the female contribution as opposed to a male contribution. But I do think it obviously, one of the problems with constructive trust as well is the fact that it's a discretionary matter, right? So there's no presumption of equal sharing. So you have discretion, and discretion in many respects is in the eyes of whoever you're in front of. And for instance, in a case in Alberta called Sworn, a relationship whereby woman and man are working on a family or ranching operation, and he spends a lot of his time, he's a cowboy, and he spends a lot of his time doing roping, roading. And when he was away, she was running the farming operation. But then she had twins, and she didn't work as much on the farm. And he says this in his decision, the justice. she didn't work as much on on the farm anymore. And that reduced her entitlement. But she had twins, for God's sakes. Of course, you see, if I was sitting on the bench, right, having had friends who have had twins, knowing what the horrendous amount of work that is, I would have given her more than 50%. But it was a perception, because she wasn't contributing anymore to the business part of it, being the ranching operation. She wasn't going to get. So she ended up with 25% of an operation that was in the millions of dollars. And so
the question would be, why are we undervaluing homework in relation to paid work or outside work?
Well, I think, I've talked to a few judges about this, right, in terms of, and they've seen a shift as well, because now you have more of the modern father, right, who spends more time doing a bit. Like in Vanessa is a good example. I mean, he quit. He sold his business. They moved back to Nova Scotia, ostensibly because she wanted to live there, because she was closer to her family and was getting help. And that was seen as a big deal. And now we've got more fathers who are participating more, and you read the cases and they will say this, participating more in the child care. And therefore, they're given a fair bit of credit for that, and that is offset against the contribution she made. I almost think, in my view, if you are better off in some ways in constructive trust if you haven't worked outside the home, if you have stayed home strictly and looked after kids. If you have worked outside the home, which means that you've had child care, and your spouse has helped somewhat, the benefits that you got from that relationship are going to be viewed considerably higher than if she was straight at home mom and looked after the kids. But that's less and less of these relationships, right? You're seeing less of them. But it is a very different concept when you're starting out with 50-50 as opposed to 0. And what's also interesting is the judges I've met, it's me, like the judge who decided this case, and I really like him, the sworn decision, I really like him. But I had done a case just a year before. Parties married, exactly the same fact situation, except my client didn't have twins, she had 2 kids, but not twins. And she had never stepped foot in her husband's business. Never. Ever. She ended up with $2.5 million, got 50% of the increase in value of a business. He decided that. He never thought one bit about, and it never crossed his mind. I asked him this. It never crossed his mind to think about what contributions she was making or not making. She was at home full time with the kids, and that was good enough. A year later, he decides the common law and sworn. He gives her 25%, where she did a lot more in that business than my client ever did. And those 2 cases were really a big contrast for me when I was thinking about doing this PhD. But when I talked to the judge about this, he said to me, well, yeah, you're right. Because I asked him about these things, and he said, I guess a marriage license means 2 bits to the dollar. And in a way, that's what it meant. Like I thought I'd call my PhD this, 2 bits to the dollar. But, and almost all of the judges that I talked to, they said they should be included. It's interesting, and yet I only spoke to judges who were given the 30 or 35%. I mean, I spoke to the ones who were doing these cases, and they wanted fairness. They all said that. But they felt constricted by the law, that it wasn't a presumption of equality, and that they had to weigh these benefit things that they kept talking about, benefits, right? And that, because I think it was amazing talking to the judges, because every single one of them that I talked to, in my view, maybe I just got all the good ones, but were just believed in what was fair, but they felt they had to follow the rules. So.
Let's see if we can get another question.
Just a really quick question. So one thing you touched on in your talk is the difference between, I guess the worries that we have between the value of autonomy and the vulnerable people that are affected. I just wondered what your thoughts are on property agreements. So I know the Family Law Act makes it clear that, parties to the contract out of presumed sharing of certain property. Obviously, that's going to be, supporting the idea of autonomy. And I know there is a way of, I guess, setting it aside if there's shown vulnerability. But I guess, what are your thoughts on this particular provision?
I think any agreement, when you have, if you're including common law folks in the intermarital property regime, there has to be, they have to have the right of that autonomy, just like marriage folks. I mean, I do cohabs and prenups all the time. The last thing I tell clients as they're waltzing out of my door after I've done the divorce, don't forget the prenup. I had that conversation this morning with a client. So for those people who are in a position where they say they don't want to get married, they want to have property, and they want to keep it separate, then yes, let's do a contract. But in Alberta, unlike BC, in Alberta, we have very, very strict rules in terms of how we do these agreements. And you have to have independent legal advice. You have to have disclosure under a recent Supreme Court of Canada decision. And we have no provision in Alberta for the fairness clause. You can attack an agreement on basis of unconscionability, mistake, and that sort of thing, but not on the basis of, quote, fairness, where there is a provision here which allows for some attacking of agreements on that. But you have to give people the right. But it's the vulnerable people who are not going to, if you say it's an opt-in, they're not going to opt in. Because I can tell you that Mr. Eric there at the Supreme Court of Canada, he owned the CIRC. Super rich. This guy spent $38 million when he went up in space. When he was in that situation, he knew what the law in Quebec was. He knew that if he didn't marry Lola, that he wouldn't have to share his assets. Right? So in that situation, to say, let's have a provision where we opt in, that would have never happened because he never would have opted in, right? He would have said, which of course he did. The only time he said he was going to marry her is he said, I'll marry you on April 1st, but in Quebec you can't marry. She can't marry on April Fool's Day. That was his big joke, And not that is in some ways the power imbalance on Eric and Lola too was amazing. I mean, she's 17, she's Brazilian, she's beautiful, she's going to high school. He meets her on a beach, and then he brings her up here. She's speaking Portuguese, of course, in Brazil. Brings her up to Quebec without her family, has 3 kids with her. Had he married her, she would have been entitled to a share of the increase. Not obviously not half of the value of the CIRC, but I can tell you that the CIRC went up a lot during the course of that relationship, So, it's always that vulnerability issue, and maybe that's paternalistic, and some people would be criticized. And I know in Quebec, I've had that come back to me. You're being paternalistic, but when I'm looking at this yesterday as I'm taking the plane, and I see that the world, despite what we want it to believe, in BC, the public servants who make over $500,000 in 2012, there was one woman, and the only reason she made over $500 is she retired and got a severance package. That is the world we still live in, in terms of inequality. There's a really good book that has just come out on this particular issue and inequality and various things, but there's a really good chapter on domination. I can't remember her name now. But anyway, there's on Canadian inequality.
All right. One last one. Quick question, quick answer.
Okay. So you want to give a little bit more comment on the BC New Family Law Act, which came into effect last spring? So how do you feel about that?
I was happy with it. The only question with the BC Family Law Act in terms of the opting out, in order to have an agreement, I think that they should have put provisions similar to Alberta requiring certificates of independence, so that both people get their own lawyers, and so it's done with proper legal advice. Because if you're going to opt out of of your Matrimonial Property Act, you need to do it with open eyes, right? And so that's the only thing. I mean, and you've got a 2-year provision, but the reality is that people who live together for 2 or 4 years, those aren't the ones that are going to court. It's the long-term relationships that I see. Those are the cases, that are actually, people are making claims. So as far as I know, there hasn't been a major, there's not a lot of big outcry about this provision, including common law folks. They're just, I know I had a girlfriend whose son was living from Alberta, whose son was living in BC with his girlfriend, and she emailed him, "Congratulations, today you're married." But I mean, the world hasn't, and the world did not change in Saskatchewan or Manitoba when they brought in the legislation. In Manitoba, they don't even think about it. It's the same thing as in matrimonial property. When we brought in the legislation in '78, and the rest of the country did around the same time, the fact is that the world didn't change. And now I get men in my office all the time, and who I act for. They never say to me, if they're married, they never say to me, well, it shouldn't be 50-50. I mean, there's a culture of thinking that is fair. Even the rich guys with the oil field. Yeah? And so, thank you.